So what do you think about coverage for cyber insurance? And I wondered, should a board, I know there's no statutory penalty for it. Maybe there should be, but should a board have protection from cyber claims, thefts online?
We think there's all kinds of exposures out there for the association in terms of cyber liability. Some associations, for example, through their management agent, collect credit cards for monthly homeowners dues payments. Privileges to access areas such as recreational facilities and so forth sometimes require copies of ID. And it's not uncommon for driver's licenses to be presented at an entry gate and photocopied when guests or invitees are visiting the premises. These are all areas where you could have a breach of their personal identifiable information. And if there's an inadvertent breach of that information, it could be potentially liable.
Well, if there is a theft of intel, a cyber crime, then there are all sorts of things a board then has to do. Basically send out notices, the kind we get, like when Apple gets hacked or Google or something, Facebook. We all get these notices basically to say, protect your private information in addition to the financial risks as well. I have had, I want to say 5 clients that have had funds embezzled over the years. And 2 of those, I think, were online thefts. And it was very difficult to get reimbursement for that because the association didn't have the right coverage. But
that's different than cyber liability, where with the computer theft and funds transfer fraud on the fidelity bond, where you're stealing money. The cyber liability, on the other hand, is stealing the records.
A really good point that we shouldn't have lawyers talking about this. We need insurance professionals like you guys addressing the issue.
It's interesting, getting back to that notice requirement, Steve, I'm told that on average it costs about $220 per record to meet all the notice specifications, and that's not including any exposure if indeed those records are used for nefarious purposes. But just to meet the notice requirements, $220 per record. So if you've got a 200-unit association, that's north of $16,000 just to notify.
Tim, aren't they also required to monitor the credit?
Yeah, that's a part of the 220. Exactly.
I think the amount depends on, what records are being requested, how many of them, the management company fees that are involved. But the legislature has made a determination that transparency is a way of minimizing the chance that directors will abuse their authority. And the way they do it is with these sunshine laws in every aspect of governance, whether it's the distribution of the annual policies, the requirement that we provide members with records on request within 10 days notice or 30, again, depending on the age. The fact that we have to publish the agenda 4 days prior to a meeting is another way of minimizing the chance that boards will, secretly meet and abuse their power. The ban on email is another example.